want to move the ball forward, well, you're not doing it as a city. You're doing it on the backs of your business owners and your individuals who are subject to lawsuits now where they were not before. You're creating a new right to sue where there wasn't one before. And the way that your law is written, because there's no exemption, for example, for small employers, that means any size employer can be subject to the lawsuit. Any individual, as it's currently written, who is, a manager or someone who works for a business that someone files a complaint against, well, that individual can be named personally, have their personal assets, their personal well-being subjected to liability from one of these. This makes your law very different from most others, in that it gives that immediate right to sue, and it immediately subjects someone to having to hire an attorney to answer a lawsuit. And even if you win a lawsuit, let me tell you, it can be financially devastating. I don't know how many people have $10,000, $15,000, $20,000 sitting around to go win a lawsuit, where the likelihood of you actually getting your fees back on the other end is very small. Now, there was an attempt in your law to say that if it's a frivolous suit, if it doesn't have any merit, then the person would have the remedy of asking the court to award their attorney's fees back to them under Florida Statute 57105. Well, I think any litigator will tell you it's really hard to get attorney's fees under 57105. I would say it's nearly impossible. I've actually only seen it happen once, and it was reversed on appeal, and I've been practicing for 15 years. Now, I'm not saying it doesn't happen. I'm talking about it in my personal experience. So this law is very bad for individuals and very bad for businesses, regardless of religion. And you look at the categories that are involved. Sexual orientation. There's no shortage of experts who have studied this subject, and they put a lot of study and a lot of effort into it. There's still no consensus on how to define it. There's no objective way to identify someone discrimination based on sexual orientation. One of the defenses that a business owner has to a discrimination suit is they can look out over their organization and say, well, I have this many black employees, or this many female employees, or this many employees over 50, and they're all being treated well. Well, they don't have that ability when the category is sexual orientation, because they don't know what they're dealing with. It's not like they can ask the question, hey, what's your sexual orientation? They don't have an objective way to even check themselves to know whether they're doing a good job. And when it comes to gender identity or expression, I think we have to be honest here that not even common sense really helps us get this right. The categories, the titles, the labels given to LGBTQ, transgender, tranny, whatever, it's accelerating, and it's going to continue accelerating. Well, calling someone by the wrong title, or in the transgender case, referring to someone by the wrong personal pronoun, if you call the person he, honestly, when in good faith, when they want you to call them she, that is discrimination as it's currently identified. I've run out of time. Would be glad to answer any questions that you have, but there are other specific areas of this law that would take it outside of the norm. I think there is no exemption for businesses in the public accommodation. There's no real religious exemption in public accommodations, and I'm not sure if that was intentional. But I believe there's several other problems, and I think you agree on.
Does anyone have any questions? No. We're in the workshop. Do any commissioners have any questions, John?
I have not received, or maybe I just missed it.
It's right there.
It's right here, I haven't gone through it. Do you have the list of the problems that identified?
They're not specified in the memo. I made a quick list of them. The immediate right to sue, individual liability exposure, the lack of a small business exception. In the religious exemption, it's worded to track a part of the Federal Civil Rights Act or the Civil Rights Law that deals specifically with employment, and I'm not sure that you can read that to find that there's also a religious exemption in the public accommodations field. Where this comes up is, let's say you have a church that wants to make sure it only does wedding ceremonies that comply with whatever its statement of faith is. Well, if that church ever opens its doors to people who aren't members, which many churches do just as a matter of outreach, they may subject themselves to the public accommodations laws and have to handle anyway that walks through the door. So it's not clear to me, and I don't know if it's intentional, that there's a public accommodations exemption even for religious organizations. There is, let's see if there's anything else specifically. There is, someone brought up the Chick-fil-A example. You do have what's called the bona fide occupational qualification privilege. In other words, Hooters can say, well, being a woman is a bona fide occupational qualification to do this particular job, and I think most people accept that. I don't think that is really your issue. The issue is not knowing enough, not being able to objectively determine, based on sexual orientation or gender identity, exactly what you're dealing with as a business owner, and being able to look at your organization and know if you're even doing a good job, or you get blindsided by one of these suits. Yes, sir.
Just talking about Chick-fil-A, does Chick-fil-A go ahead and ask whether or not a person's an agnostic, an atheist, a Christian, or a Muslim?
I don't think so.
Realistically,
you may recall back in 2012, in fact, at the time that the Jacksonville City Rights Ordinance was coming up for a vote, the owner of Chick-fil-A, Dan Cathy, made a comment that he supported the traditional Christian definition of marriage, one man and one woman. Well, his stores were boycotted, and his stores, Chick-fil-A, were attacked as being discriminatory, when there was not one case where an employee or a customer said, I've been discriminated against by Chick-fil-A. I don't think Chick-fil-A would turn away an employee who was otherwise qualified based on any of those categories, because I think as a business, they just decided they're not going to do that. And I don't think we're required, even a Christian business isn't required to inquire into those things for serving sandwiches. I mean, it's commonly brought up, well, we don't want any law that's going to allow someone to not serve a person at a lunch counter. That's not really the issue that we're dealing with here. I don't know of any, I have a lot of Christian friends, I don't know of any of them who want to see someone not served, period.
or the fact that, an individual who would be a transgender or an individual who would be homosexual, and doesn't, I mean, whether or not you know that they're homosexual or they're not homosexual, why would the Chick-fil-A's turn around and say, hey, listen, you know what? I'm going to put this on my application, and you have to put down whether or not you're homosexual or not. So,
I've never seen that.
so I don't. Again, that's a theoretical, statement, and I don't really agree with the fact that that's a major concern.
Right. I think the issue is because gender identity or expression is the way it's defined, it includes behavior. Behavior that a person says is part of how I express my gender identity.
What do you, well, give me an example of what you're saying, of how a person will express. In other words,
Yeah,
if
sure.
an individual ends up, who is psychologically or a female at that time, feels as though is female, and then starts to wear a skirt or whatever else, and then, starts going ahead and having a change, medical change at that point, and that individual feels as though she is female.
Well, it's a great question, because I think if you have dress codes come up, if you have a policy of professional dress at your office, I think we all agree that's a reasonable thing to have. Well, if someone else's conception, someone who identifies as transgender or a related category, if the way that they express their gender is to wear mini skirts and tank tops, immodest or revealing dress, and they say, well, back off, that's how I expressed my gender, then you have a problem. Dress codes are difficult to enforce when you have a law that, on its face, again, we have to go by what the law actually says. It says gender identity or expression includes behavior or expression. Expression is a really broad concept.
My understanding, though, is that the business could go ahead and put down exactly for everyone what they're going to have to wear. And therefore, if an individual says, well, that doesn't really fit me, that's not accepted by the business itself, and that will go ahead and be held up by the Supreme Court that they can go ahead and do that. Because it's discriminating against everyone else if that individual ends up going ahead and wears their miniskirt, as you were saying.
Yeah.
So again, I'm trying to understand where you're coming from on that, the expression. So if you'll explain it a little bit more on that.
Well, it's a fair question, and I don't even know that we're disagreeing. What I'm saying is, it becomes difficult. You're putting compliance costs and efforts onto employers where they didn't exist before. For an employer who wants to be law-abiding, who wants to honor everyone and respect everyone, who has a new transgender employee, or an employee who one day decides, he's been a male for 20 years, and tomorrow he comes in and says, I want you to start referring to me as a female, and use she and her when you refer to me, and I'm going to dress as a woman dresses. You're thrusting businesses into this area, unknown territory. How do I comply with this and not get it wrong? And if you make a misstep.
My question is to you, is as a Christian, you would turn around and say, well, I'm going to fire you?
No, absolutely, no. I'm not suggesting that anyone that anyone should be fired or looking for the right for someone to fire someone or not hire someone based on
Well, then explain to me exactly what you say. If an individual feels